Session resumes. Yes, Mr. Berger.
He's waiting for you.
Yeah, I said yes.
Thank you, Chair. Thank you. I apologize, I didn't hear that. I was busy with the first main issue, and that is on the causal link between the mandate and the inquiry. It seems as if the authors of the interim report are aware of this. If you have a look at the report, Chair, at page 3, they seek to confine the scope of the report. And they address it under 2 bullets. The first bullet, they said, first, it addresses factual issues which are relevant to the events of the 9 to 16 August. And those really are all the chapters except for chapter 5. And I have no qualms if that is used simply as a backdrop. Can't do any harm, it's chicken soup. And that's in fact what they say at the last sentence there. These chapters are included not for the purposes of making findings against any parties, but because they provide important contextual information. But of course, there's no causal connection between debt collecting and the deaths, but I don't mind if they want to write in a report about debt collecting, and if somebody wants to read it in future, no harm done.
But I remember that in the public debates that followed on the events of August 2012, indeed speeches by cabinet ministers and others, reference was made to the debt collecting aspects of the garnishee orders and micro-lenders acts. And there certainly is a public perception out there that there is a link, and so it would not be inappropriate for us to present the objective evidence which has been obtained, which bears on those issues.
That's why I say we have no qualms with that. I think there's a real concern out there. But Chair, the simple point I make, you cannot make a finding on that or a recommendation on that. That's outside of your mandate, because you have no indication that there's a link between micro-lending and the police shooting protesters. That's missing. But then they come to the second bullet.
I don't want to take up too much of your time, but it's not quite as simple as that. The police shooting protesters is the end of the chain. What you have before that is certain behaviour by the protesters. You call them protesters, I call them strikers. The evidence we have is that the strikers firstly embarked upon an unprotected strike. The evidence tends to indicate, or it may be a controversial matter, but tends to indicate that some at least of those involved in the unprotected strike wanted to enforce the strike by what I call murder and mayhem, in other words, violence and intimidation and damage to property and so on. That conduct then, in turn, as the next link of the chain, caused the police to bring substantial reinforcements to the area. And that culminated in the events of the 10 deaths, as we know, before the 16th, culminated on the 10th in the shooting of 34 people. But it's not a simple matter of a connection between event A and the shooting by the police. The shooting by the police is the end of a chain, and the fact, if all the events that preceded, all the relevant events which preceded the shooting, if they are linked, if they are part of the chain, then obviously one has to start at the beginning of the chain and ask what caused the first event, the second event, and so on. So I don't think we have to have an extensive debate on it. What I'm saying to say simply the shooting by the police is this thing that happened a year before linked to the shooting by the police. It's not just a question of, well, where's the link with the shooting by the police and the first event? You've got to look at the whole chain.
No,
with respect, maybe questions of foreseeability and other things as well, but and remoteness, but these are all matters that I'm afraid we have to look at.
No, but I'm addressing you in the context of legal causation. This is not a debate in the air. My learned friend, Mr. Mpofu, is quite right. On a broad spectrum, a non-legal approach, this started when diamonds were discovered in 1880 in Kimberley. This started with the migrant system in this country. This started with apartheid and But, sir, that's not your mandate. You can't inquire into that. That's why I say you can't inquire into micro-lending We know it was one of these multitudes of background facts. That's outside of your mandate. And if you bring out a finding, that's why my learned friend Mr. Tipp is quite right. You can't bring out a finding that the banks are overcharging and they're unkind to the people. That would be outside of your mandate. And it's in that context that I say.
I don't want you to be under misapprehension. I don't think, this is a prima facie view, obviously. I don't think it's as simple as that. If overcharging by the banks, to take the example that you put to me, is in fact causally linked, and remember, causation is a question, firstly, of facts, and secondly, a question of legal liability. So, on the factual point, then one applies, I take it, the doctrine of causa sine qua non. You have to look at but-for facts, look at all the facts which contributed causally to the results. But that, of course, takes you very, very far back, and the courts don't do that. They limit the factual causation by principles of legal responsibility.
Correct.
And there are various tests that operate there.
Correct.
I don't want to go into debates about the so-called supple test of causation. That
on any test, the micro-lending is not an issue.
Well,
on any test.
We don't have to debate that now, but all I'm saying to you is that the inquiry is a twofold one. Factual, which, of course, goes back to enormous lengths, and also legal responsibility as well. But I don't know that necessary for you and me to have a difference on that issue. I understand the significance of the point you make.
Chair, the only importance for me is to convey my submissions to you and your commissioners. Otherwise, I'm not performing my function. Why I'm confident that micro-lending is not an issue here. I would have been wrong if there was evidence in the preceding 2 years by strikers, by injured people, to say, had it not been for the garnishee orders, I wouldn't have needed 12,500, I could have lived. But these banks, they really charge you. That opens up a causal link. And he says then, and that's why I was very angry, and I went to the copy. We have none of that. And what is left now is, there are some experts coming, and Lonman, they're not going to talk on micro-lending. They're not concerned with that. So I'm confident that that link has not been established. And in fact, the authors of the interim report knows that. That's why they say, for chicken soup, we're going to file something, but we won't ask anybody to bring out a recommendation on that. But I want to go to the second bullet here on page 3. Second, it addresses the specific failures on Lonman's part to comply with housing. Now one reads with interest, what is the causal connection between housing and the shooting? And they say, I pick it up 4 lines from the end, the evidence leaders are of the view that Lonman should be held accountable for its breach and repudiation of the hostel conversion and housing obligations in its social and labour plans. Where does that mandate come from? One asks. The evidence leader sees no unfairness in calling upon Lonman to answer specific allegations in Chapter 5 within the remaining time. Well, that's just, if with respect, that would be reviewable. That's outside of your mandate. There's no basis for that.
And look what she then goes on to say. She filed a comprehensive case to report.
I'm sorry, there's some ladies in the chamber at the back who are talking among themselves, having a conversation. May I suggest if they want to have a conversation, they have it outside. We can't hear exactly what they say, not that we wish to do so, but the fact that they're talking is disturbing and makes it difficult for us to hear what council is submitting.
Another report, the comprehensive report is still...
Yes. Then the authors go on at page 4. Where they say this research report is the product of a small part of the total research conduct in the Phase 2 process. In order not to waste the resources that were devoted to Phase 2 both before and after the deletion of Clause 1.5, the Phase 2 researcher will file her comprehensive report with the Commission together with the evidence leaders' written arguments. The Commissioners will not be asked to make any findings on the basis of this comprehensive report, but they will be requested to forward it to the President together with their report, so that the government departments and agencies that are ultimately tasked to investigate all the issues that were to be traversed in phase 2 can have the benefit of the research that's conducted by the Commission in this regard. Well, we with respect submit that the mandate, which we haven't seen, would not have been that wide. We would suspect the mandate would have been, the lady would have been showed the mandate of the Commission as per the Government Gazette, and that's really the starting point and the end of that debate. But let me go to the second issue, the submission that probing these obligations in vacuo is not helpful. Is that file by? May I just read from a report which we've been handed in this?
So probing these allegations in vacuo, is it?
Probing the obligations in the context of the SLPs in vacuo is not meaningful. Chair, we've been handed a report which I'll ask my attorney to hand up to you. I think she might have received it from, I don't know, from where? From the evidence leaders? From the evidence leaders. It's a report by a gentleman called Ralph Hammond, Hamann. It's heading Lonmin's Mining Charter Compliance and the Social Conditions Around Mines near Marikana. The introduction says, this is a briefing paper submitted to Kelly Forrest, Senior Researcher Phase 2 at the Marikana Commission of Inquiry. The Commission's mandate is to investigate the matters of public, national and international concern arising out of the tragic incidents at the Lonmin mine at Marikana in the Northwest Province. I'm more interested in page 25 of that report. The author says the following. The capacity constraints of local government are well known, so it is possible that mining companies are filling these widespread gaps. However, it is likely that there is a systematic shift in government's spatial emphasis that expects mining companies to fill these gaps and de facto replace the state in mining areas. This expectation is explicit in various levels of government. Then a quote. And the quote comes from an interview. The municipality saw this as a way to deliver on their agenda, to get companies to put in roads and so on. It should have been about augmenting what government does, but it became so that companies became delivery agents for government. I was at a community celebration. They had invited the mayor. We were launching a community project where we had built a community hall, a road, quite a few facilities. And the speaker after speaker, including the chief, were saying to this municipality guy that every time they go to the municipality for help, they get told, you the children of the mine. Whatever your needs are, you go and ask the mine. Don't come here. We have lots of other communities that don't have mines that look after them. This happens within government as well. I was told by the municipality in May, quote, we don't have rubbish bins and every time we go and ask for a budget we are told go to the mines and ask for the budget from them, unquote. The mayor gets told this when she goes to ask for budget from the province. I read that because I illustrate to you that to look at Lonmin's failure to provide housing in a vacuum is unhelpful. And if we're going to prove that, if the order is phase 2 Lonmin housing, we would like to consider subpoenaing the mayor, the MSC for housing in the Northwest Province, the National Minister of Housing, people who have under the Constitution the prior responsibility for housing. And we would like to probe, how does development take place? How does sanitation and water and electricity take place? What are your schools like? It is an inquiry which we simply cannot embark upon at this late stage of the debate. We address this in our...
If you've been sued by, I presume, by the Department of Mineral Resources for compliance with the conditions which were part of the social labour plan, which Mr. Shaskison referred, could you have raised those matters as a defence?
It's a different question. I don't know whether I could raise it. I don't know whether you mean by sue, I get sued in a court of law. I would probably, if the department...
I understand, I'm sorry to interrupt you. I understand that from time to time the DMR issued directives to London to comply with their obligations, and,
Yes.
and they appear not to have done so.
Yes.
If the department...
No, Chairperson, they did. They
Right.
did. This was one of the documents that London disclosed to us in the last 2 weeks.
No, so I didn't say... Sorry, what did you think I said? I said my understanding was that the DMR sent them directives. Yeah, that's what I said. And I take it that the whole purpose of the debate is that the directives weren't complied with, otherwise we wouldn't have the problem. Now, if the department had then brought an application against Lonman for an order directing that they comply with the directives, could the Lonman have raised as a defence? Well, we didn't comply, if they didn't. I assume for the purpose of the question they didn't. We admit we didn't comply, but the province didn't do what they should have done. The municipality didn't do what they should have done. The national department didn't do what they should have done. Therefore, we have a good defence to a claim based upon directed to us to comply with our obligations. Would such a defence have been sustainable?
I don't know. I suppose, and I'll have to take instructions on that, that would depend on Lonman saying to me, I can build a house, but I don't provide electricity. Electricity must come to my township. There's no electricity. I can provide taps in a house, but I don't provide water. That's not my obligation. That's roads. I don't know who they are. They not provided, so you can't get... I don't know. There may be defences out there, but it is a multifaceted inquiry which is not in this Commission's mandate, for which you're not equipped to inquire into. And my second point is simply to inquire into Lonman's alleged breach of its SLP obligations. It's not going to help anybody. There's no causal connection, and it goes nowhere. But I've really made that submission. We've made that submission in the letter quadruple N1 in paragraph 5.3 and 5.4. May I just end off on this issue with that?
Got 5.3.
5.3 on page 3 of that letter,
yes,
sir.
5.3 and
5.4.
And 5.4, thank you.
Pick it up 4 lines from the top. But housing for employees also involves an inquiry into matters such as housing and infrastructure development by the local authority concerned. And the day when we settled this letter, I just quote an article from Business Day. In Business Day of Thursday, 7 August, a spokesman for Human Settlements Minister Sisulu is quoted as having said, quote, a lot more could have been done to develop mining towns if administrative processes at local government were more efficient. Municipalities are expected to make land available for housing development, and the Housing Development Agency has been set up to assist. Now, you ask me, sir, rhetorically, would you have a defense? I would say I'd take instructions, but there's a plea hidden in here. There's an answer here. May not be a complete answer, but it's clearly opening up a larger debate than the one sought to be explored in the interim report. And in 5.4, we conclude then to say this issue cannot be decided in isolation. My third point, if you just bear with me, sir. We submit as a third point for not opening up this inquiry that to the extent that the Commission's inquiry at this late stage wish to include phase 2, that will be unfair to Lonman. And we say this for a number of reasons. Thus far, and for understandable reasons, the causal link between any possible housing debate and the deaths have not been explored, for example, and I've just noted a few witnesses with whom it should have been explored. The Bishop Sioka. I didn't ask him about that because he didn't offer that as a reason for the tragedy. The trade union leaders. I didn't ask it for Mr. Matunjwa, Mr. Zokwane. I didn't go there because nobody suggested that. The injured and arrested people and the families. None of them suggested this link. Not surprisingly, we didn't explore it. Da Costa. Da Costa was cross-examined in the context of he spoke to the workers and later on Lonman should have spoken. Nobody asked him whether they complained about housing. In fact, his evidence is they complained they wanted more money. And it wouldn't follow with respect that if they have a good house, they don't want more money. One's experience is anything to go by, the better your house, the more money you need. So those issues have simply not been explored. And to now suggest London must simply bite the bullet and on two witnesses identified by the evidence leaders address those issues and get rid of it, well, that would be hugely unfair. Hugely unfair in a process where the police has led a non-expert, Brigadier Makwanazi, for 18 days. He professed he doesn't know anything about the subject, so he was led for 18 days. General Annandale was cross-examined for, I think, a month. My client gets 11 days to call 6 witnesses. I haven't started on phase 2 because I don't know whether it's in. Well, that would be unfair. And with respect to the extent, and I can say this because I've complained for a long time about the pace. To allow extensive cross-examination as being fair, and then to put my client into this time straitjacket will be unfair. We do not accept that there's an axiomatic link between housing and the deaths during the period in issue, and to the extent that the interim report seems to assume that, we differ from that assumption. A second reason why this is unfair is, I don't know whether this phase 2 is going to be introduced. And if it is going to be introduced, what issues in phase 2 will be introduced? But once I know that, and once I've seen a comprehensive report, I will then be in a position, hopefully I'll lean on my learned friend Mr. Bam, to go and prepare that, to consult with witnesses, to research it, to get expert advice, to file expert and lay witness statements, and to call witnesses, to consider whether to ask for other witnesses to be subpoenaed from other institutions. Well, there is simply no time for that. My learned friend Mr. Mpofu is again correct. Till the end of September, this process cannot be accommodated in this commission. May I, in this context, draw your attention, Chair, Commissioners, to the interim report, page 52, to show you what type of investigation will have to be launched. At page 52, in the middle, there is a quote. It starts off, senior Lonman managers have long cognizant of the risk linked to housing and social conditions around the mines, probably more so than other companies. Lonman's Director of Corporate Affairs said in 2002, quote, you don't have to be a genius to see that the real threats are in the area unemployment, crime, the disrupted social fabric created by the migrant system, and the fact that you have a lot of single men living in hostels in proximity to your operation. Now you can see the social ills here being identified. They're still there, tragically, but housing is but one subcomponent of that. If you look at the footnote, Chair, you'll see the footnote takes us to page 64. That was an interview with Tony Riley, the Lonman Corporate Affairs Director, on the 7th of April 2002. And there's a whole history behind that statement and an inquiry to be made. Now, I'd like to speak to this gentleman, if he's still around, get a statement from him, put that into perspective, and address these issues, if it is going to form part of phase 2 of this debate. Well, it'll be very difficult to do it at this round. And this preparation will have to be done at this stage, certainly without a final report from Dr. Forrest, while we're in the midst of preparing the phase 1 witnesses with whoever counsel is available to do that, without yet having identified any witnesses to deal with any new issues to be opened up, and of course, obviously, before we even have a ruling on whether phase 2 will be part of the process. I deal briefly with the submissions by my learned friend Mr. Chaskelson, and I've made it clear that we didn't ask for phase 2 to be abandoned. That would be wrong. What we say is phase 2 cannot now be introduced on the narrow issue of Lonmin housing for the reasons I've given. The unfairness my learned friend addresses by saying that's of our own making. Well, that's with respect not correct. We still today don't know whether phase 2 is going to be part of this, and we play no role in that. We play no role. We've assisted and supported the phase 1 identification, and until today, that is the status quo. My learned friend says Mr. Mokoena is responsible for the SLPs and therefore he can give evidence to that. Well, it's a non-issue, as I've submitted to you. So his evidence on SLPs as compliance is unrelated to the mandate of this commission. Mr. Jamieson, we're told, would shed light on the recurring payments to the BEE context. That's a non-issue. I'm sure some of my colleagues would love to explore that and see where the money went. That's a debate for perhaps another forum and another day. My learned friend, Mr. Tip, stresses that causation is important. We agree with that. He says that the other chapters of the interim report enriches one understanding of the social fabric. I agree with that. It can go in, it does no harm. But he warns quite correctly that if one goes, for example, into micro-lending, one should be sensitive that findings cannot be made. And of course, if findings are not made, the inquiry is not a very helpful one. And perhaps not surprisingly, he has no submissions on Chapter 5 of the interim report. Yeah, I don't want to deal with all the other submissions. Ms. LaRue, my learned friend, says what she envisages in introducing phase 2 is a limited exercise due to limited discovery by Lonmin in limited time. Well, that's really like the Holy Roman Empire. That's suspect in all three its components. This is not a limited exercise, it's a massive one. There was not limited discovery, there was extensive discovery. And the limited time is the problem, not the solution. And I've dealt with, for a change, positively with my learned friends, Mr. Nzabenza and Mr. Mpofu, where we see eye to eye that this is not the time and the place to go on to new ventures in this commission. So if there's anything that I've omitted, I apologize for that, but those are the submissions on behalf of Lonmin.
Berger? Mr. Chaskelson.
Mr. Chairperson, I'll address 3 points in reply. The first is to say something about the timetable or the timing of the emergence of documents, because Mr. Berger is wrong on 2 counts. On one count, he's cheated his client out of a year. On another, he has been too generous to his client. The second point that I'll address is his proposition is one cannot investigate this without the state, because housing is impossible if one doesn't have a service infrastructure that the state addresses. And lastly, I'll deal with his terms of reference point. So to start with the timing, Mr. Burgess was with respect unfair to Lonman in respect of when they made discovery. They made discovery in 2013, not 2014. It was March 2013. The disputes that we have with Lonman relate to requests for discovery of further documents that were made consistently over the period November 2013 to July 2014, and that were made by Dr. Forrest, by the evidence leaders, in writing at meetings. Those documents that were requested in the period, documents and information that were requested in the period November 2013 to July 2014, are the documents and information which, for the most part, arrived in the last week of July 2014 and the first week of August 2014. And my learned friend Mr. Berger says, well, look at the interim report, you see the documents that were discovered by Lonman. Well, with respect, that's partially true. You also see a fair, if one follows the references in the interim report, one sees a fair amount of references to documents and information that were forthcoming only in the 2 weeks before the interim report were produced. And part of the reason why the interim report looks the way that it does is that, for the most part, Dr. Forrest had to depend on the documents that were provided in 2013, because the documents that she wanted to look at that were forthcoming, that she was requesting in the period from November 2013 through to July 2014, were not forthcoming. So how the interim report was ultimately settled is that what it reflects is what Dr. Forrest was able to address comprehensively on the basis of what she received from Lonman and other parties up to March 2013, and then on the basis of the follow-up documents that were finally provided in late July, early August 2014. What she was able to address comprehensively, and what she was able to address in a manner that would give Lonman a fair opportunity to respond to it within the remaining 5 weeks. If she could have written a full report supplemented with bits and pieces that came dribbling in July and August, and there wasn't a constraint of time, the report would have looked much fuller. But she acknowledged that all that could reasonably be expected of Lonman to answer is, within another 5 weeks, was what was in that report. So the delays in producing information had a very real effect on what's in that report. The next point of Mr. Berger is his constant refrain that one cannot investigate Lonman's housing obligations without looking at the state's failure to deliver. Now, in principle, we agree with him. But this commission, after the deletion of clause 1.5, has no jurisdiction to investigate the state's failure to deliver. And so the question then remains, what failures on the part of Lonman are possible to investigate in a context where you cannot look at the state's failure to deliver? And that's where we get to the social and labour plans, because that's an obligation that was resting on Lonman independent of the state. My learned friend Mr. Berger seems to be of the view that it wasn't independent of the state because without services, Lonman couldn't build the houses. With respect, he's misinformed, because if one goes to the Lonman social labour plans, Lonman undertook an obligation not only to build the houses, but to service the stands as well. So if one, maybe we should introduce the Western Platinum Limited Social Labour Plan as a new exhibit, because I will give a reference to the relevant passage. Is that quadruple N4? If one goes to page 71 of the West...
Sorry, let me just identify the exhibit. The Western Platinum
Limited Social Labour Plan. In fact,
SLP,
SLP. Both the social labour plans of Western and Eastern are identical. They are joint labour plans. But my reference is, the pagination is slightly different. And my reference is page 71 of Western. And there you'll see that at the time that they submitted their social labour plan, they had already serviced 780 stands. And in their social labour plan, they committed to servicing another 4,800. And if you add 780 to 4,800, you get more than 5,500. You get 5,580. That was to be done by 2010-11, and there was a capital budget of 96 million rands that was to be allocated to that purpose. So, with respect to Mr. Berger, this was not something that depended on the local state. It was an obligation that was undertaken by Lonman essentially as a turnkey obligation. Now, that brings us to the terms of reference point, which seems to be the most important point advanced by Mr. Berger.
The question I want to ask you about that is on page 2 of Exhibit quadruple N1, Lonman makes the following statement. Importantly, though, the specific matters which the Commission was appointed to inquire into and report upon is, I take it they mean are, prefaced by an introductory paragraph which requires a causal link between those matters and the events at Marikana mine, etc. Now, where exactly is the causal link to which they refer to be found in the introductory paragraph of the terms of reference?
Well, Mr. Chairperson, with respect to Mr. Berger, he's approaching this commission of inquiry as if it were a trial on a cause of action for delict relating to death and damage to property caused in the weeks of 9 to 16.
I understand that, but before we get there, the wording of the introductory paragraph, I couldn't find, unless I was looking incorrectly at it, I couldn't find a reference to a causal link. They make the statement, they've got a passage in quotation marks, the causal link part is not the part that's covered by quotation marks. So what is the wording in that paragraph which justifies them in saying that a causal link is required? The relevant paragraph is 1.1.3, which reads as follows: whether by it, that's Lonman, by act or omission, created an environment which was conducive to the creation of tension, labour unrest, disunity among its employees, and other harmful conduct. Now, Mr. Berger says, well, you would expect a striker to come along and say, I was in an environment which was conducive to the creation of tension and labour unrest. I'm not sure that an unsophisticated striker can be expected to make a statement of that kind. But anyway, the question I'm asking you is, where is this requirement of a causal link? Apart from the use of the word conducive, which presumably would introduce concepts such as indirect causation.
Well, Chairperson, if one looks at the terms of reference as a whole, one sees that what the President is asking this Commission to do is to go beyond the test of causation that one would apply in a delictual trial, because each one of the sections of the cause of the terms of reference have as their last paragraph that test. So 1.1.6 in relation to Lonman, whether by act or omission it directly or indirectly caused loss of life or damage to persons or property. That's one inquiry that one...
As far as I understand, that's conjunctive, is it?
Indeed, they're all conjunctive.
Sub-paragraphs are all and, not or.
Absolutely, Chairperson. So the legal causation inquiry is one of several inquiries that this Commission must do, and it's in that context that 1.1.3 is significant, because if one sees what the President wants this Commission to look at in relation to SAPS, to AMCU, to NUM, like Lonman, it also wants the Commission to look at them in relation to the question whether by act or omission they directly or indirectly cause loss of life or damage to properties or person. So that category of investigation is common to everyone. But in relation to Lonman, there is a unique category of investigation, which is 1.1.3. You don't see a parallel to 1.1.3 anywhere else in the terms of reference. And that is, whether by act or omission, Lonman created an environment which was conducive to the creation of tension, labour unrest, disunity amongst its employees or other harmful conduct.
If the idea of some kind of causal link is to be implied in the introductory paragraph, which is quoted in paragraph 4.2 of the letter, then one would be surprised to find express mention of causation in some of the succeeding paragraphs relating to some of the other parties.
Indeed, Chairperson, and it goes to what the nature of a commission of inquiry is. And if I can just refer to the Safu judgment of the Constitutional Court. There the Constitutional Court pointed out that a commission of inquiry is an adjunct to the policy-making function of the executive. Now, you don't make policy.
What's the reference to the Safu case?
2000, Volume 1, essay, page 1, Constitutional Court.
Yeah,
the passage to which I refer is paragraph 147. It's an adjunct to a policy-making function. You can't make policy on the basis of investigations that apply a test of legal causation. You can't go that narrow if you're making policy. You have to apply a broader test of relevance. And so where the introductory passage comes in is that there must be some relevance shown to what happened in the week 9 to 16 August and an environment created by Lonman which was conducive to the creation of tension, labour, unrest, disunity amongst its employees or other harmful conduct. That relevance isn't to be investigated on as narrow a basis as a test of legal causation. It's much broader because it's about policy formation. What the President wants to come out of this commission is policy recommendations which will hopefully ensure that we never again have another Marikana tragedy. And if we're to be constrained by tests of legal causation which are perfectly appropriate for apportioning liability in the law of delict, we're not going to get to sensible policy recommendations because you cannot apply a test that is that narrow and is framed for individual disputes between two individual parties to a policy formulation process that is really aimed at recommendations to deal with a social problem and to prevent social outcomes, undesirable social outcomes. So we would submit that if it appears that the living conditions of Lonman workers are part of an environment that form the context that is relevant to the tragic events of 9 to 16 August, then Lonman's responsibility for those living conditions falls squarely within the terms of reference.
Can I go back to the wording of 1.1.3? Whether it by act or omission, you say there was an omission, comply with its social labour plan obligations. Whether it by omission created an environment which was conducive to the creation of tension. If the omission was conducive to the creation of tension and labour unrest, then that would be enough, would it?
Well, as Mr. Berger says, if there was just, someone cannot come off the streets and say, well, I was unfairly dismissed by Lonman last week. I want you to investigate whether a certain environment that was created by Lonman was in relation to my dismissal was conducive to the creation of tension, labour, unrest, disunity. There has to be relevance to the events of 9 to 16 August shown. But we would submit there's obvious relevance to the events of 9 to 16 August. It's recognised by Lonman themselves. At their first AGM after the tragedy, what do? They announce they're going to sort out the living conditions of their workers. Why? Because they understand those living conditions to be relevant to what happened, as does everybody else. One couldn't sue Lonman in delict for loss of support. The families can't sue Lonman in delict for loss of support because they didn't build houses and as a result of all of that, somebody died in the weeks 9 to 16 of August. But that's not the inquiry. It's not a legal causation inquiry. It's a much broader social causation, if one wants to put it that way, because we're dealing with a policy-making process here, not a microscopic apportionment of legal liability in terms of principles of delictual causation. Those are our submissions, Chairperson.
You say about the unfairness argument. Mr. Berger laid considerable stress on the submission that it's unfair at this late stage to expect his clients to deal with that as part of phase 2 that they'd have to subpoena all sorts of people and do all sorts of work and research and investigation and so on. What do you say about that?
Well, Chairperson, the terms of reference mean what they say. If we are correct on our interpretation of the terms of reference, they have meant what we say they mean for 2 years. Lonman has had 2 years to do those exercises. It was never suggested to parties that they could wait until the end of phase 1 before they started preparing their phase 2 cases. That could never have been conceived. If Lonman finds itself now in a position where it is unable to prepare as well for a phase 2 submission as it would like to be, well then, with respect, it has itself to blame, nobody else.
Mr. Berger, you did quote from some letters, I think, in the course of your address. Would you be able to provide us with copies of them? Obviously not now. You referred to correspondence.
Yes, I'm hesitant because I've scratched on mine and my attorney has left now, but we will certainly make that available.
I wanted to say, I didn't expect you to hand over your copies now, but in a day or two. As you know, we're not sitting until next Monday because of various reasons. So in the interim, if you could provide clean copies, if that's the right word, of that correspondence, I'd be grateful. Thank you.
In the usual spirit of cooperation from Lonman, we'll do so forthwith, sir.
Thank you, Mr. Berger. That's the end of the argument. We will give judgment. Sorry, we'll make our ruling on the matter as soon as we can. We can't do it obviously now. We'll now adjourn until 1:45. We will continue with the evidence of the witness who was testifying before us yesterday, Mr. Mchamba.